Hi everyone. So you filed for bankruptcy or you're thinking about filing, and now you want to know what happens to your student loans. If you're confused about whether your loans can be discharged or whether you're stuck with them forever, you're not alone. I'm Martha Warrener, a California bankruptcy attorney with over 40 years of experience. Today I'm going to break down exactly what bankruptcy does and does not do for student loan debt. There's a lot of misinformation online, so let's clear it all up. Stick around because this topic matters for anyone with federal or private student loans who's trying to restart their financial life. There's a very popular belief that student loans can never be discharged in bankruptcy. You've probably heard someone say they follow you forever or there's no way out. That's not entirely true. Bankruptcy does not automatically wipe out student debt, but it also does not mean you have no options. You just have to understand how the law works and what steps you might need to take to get relief. Student loans are treated differently from credit cards, medical bills, and personal loans. In a typical Chapter 7, unsecured debts get wiped out at discharge. While student loans are not priority debt like most taxes, they are a separate category unto themselves, and under the bankruptcy code, they are non-dischargeable unless you meet a specific legal standard called undue hardship. This is where most people start to get confused, so let me explain exactly what that means. To eliminate student loans through bankruptcy, you usually must show the court that repaying the loans would create an undue hardship on you and your dependents. This requires something separate from your main bankruptcy case called an adversary proceeding. It is basically a lawsuit within the bankruptcy case. Once you file the adversary proceeding, government's attorney must provide an attestation form for you to fill out. This form is often the means for you and the government to arrive at a stipulated set of facts regarding your financial condition, efforts to repay the loan, etc. Historically, courts used a very strict test called the Brunner test. It looked at three things: whether you can maintain a minimal standard of living if you have to repay the loans, whether your financial situation is likely to continue for a significant portion of the repayment period, whether you have made a good faith effort to repay the loans. That test made discharge difficult but not impossible. I've seen people win discharge, but it requires evidence, documentation, and for most people, legal help. Here's something many people do not know. The Department of Justice and the Department of Education issued new guidance for handling federal student loan discharge requests in bankruptcy. The attestation form is one of the means for implementing that guidance. This guidance encourages government attorneys to stop automatically fighting every borrower. Instead, they're directed to review your financial situations and potentially agree that your loans should be discharged. Once you file an adversary, you should receive the attestation form. Fill it out and return it. It provides the means to stipulate to the relevant facts regarding claimed hardship, including income, expenses, and the likelihood that your income will increase in the foreseeable future. An additional factor in the evaluation is your good faith efforts to repay the loan. These include a history of payments, applying for a deferment, applying for an IDRP plan, or your efforts to seek meaningful employment. The result is that many loans are now getting partially or entirely discharged without going through extended court battles. This shift is the first in decades that the federal government loan discharge has become realistically achievable for most people. If you have federal loans and are considering Chapter 7 or 13, this new guidance may help you far more than you realize. Private student loans, on the other hand, are different. Some private loans can be discharged even without proving undue hardship. For example, loans for unaccredited schools, certain bar study programs, or loans above the cost of your attendance may be treated like regular unsecured debt. Many people do not realize that their private loans may not meet the legal definition of a qualified educational loan, which means they may be dischargeable automatically. If you are not sure which type you have, pull your loan documents and speak with a bankruptcy attorney with expertise in getting student loans discharged. There are also third parties that specialize in the area, and their fees are usually reasonable. A small detail can make a big difference. In a Chapter 7, your student loans do not go away automatically. Even after an adversary proceeding, you will still owe whatever is not discharged. However, many people find that eliminating other debts makes it much easier to manage their student loans. You can also combine a Chapter 7 discharge with income-based repayment, forbearance, or consolidation once the bankruptcy ends. In a Chapter 13 case, your student loans become part of your repayment plan. You may only pay a portion of what you owe during the 3 to 5 year period of your plan, and sometimes the payments on your student loans are paused while you pay your other creditors. Filing bankruptcy does not automatically put your student loans in default. It does not cancel your income-based repayment eligibility, and also your co-signers may still be responsible. At the end of your plan, any unpaid student debt balance will still be there, but the interest may stop accruing during the case, depending on the type of loan. For many people, this gives them breathing room while they reorganize their finances. A few things people often get wrong. Your loan servicer cannot harass you while the automatic stay is in effect. You cannot be denied federal student aid solely due to your bankruptcy. Knowing these facts can help you make better decisions as you plan your next step. Here are some signs it may be worth pursuing an adversary proceeding. You are living on a fixed income. You have a long-term disability. You've been in repayment for many years. Your current income is unlikely to rise. You've already tried income-based repayment. You are carrying other financial burdens that make repayment impossible. These are the types of situation where courts are more open to granting discharge. If this video was helpful, give it a thumbs up and subscribe for more clear, simple guidance on bankruptcy and debt relief. This video is for educational purposes only and should not be considered legal advice. Every situation is different, so please consult with an experienced attorney about your particular circumstances. And if you'd like to schedule a free half-hour consultation with me, you can call me at 760-409-7705 or email me at martha@bankruptcysage.com. My contact information is in the description below. Thanks for watching, and I will see you in the next video.